time since I've done one of my videos, and in this video I want to look at a legal matter. In this video I want to discuss the concept of rule of law and what it actually means. It is important to understand this concept, as this is what governs us and defines much of the world we live in. How decisions are taken, how disputes are settled, all these things, they all which they make up our world, and we can only understand them if we can understand that our world is governed by the rule of law. Well, I'm talking specifically about the UK because that's what I've been studying, but I am sure loads of other countries which I've been looking at, like India, etc., they do also have the concept of rule of law, but this is from purely British angle. Now, I may need to divide this video into two. We'll see how we're doing for time. And what I was going to do is do the first half on Dicey, A.V.Dicey, and the second half on Lord Bingham. So we'll see how timing goes and we'll just see. So I'll just start my video now. Okay, so from what I understand and I've been taught about the rule of law, the sort of discussion surrounding it seems to have originated from A.V.Dicey. Now, I do think, and I'm sure that I'll be able to find discussions of this concept because it's something which seems so core. It seems to be the core of law. So I think it probably came before him, but was maybe not given the title rule of law, or is probably not as significant as A.V.Dicey's contribution to the discussion of rule of law, which he discussed in 1885. After that, there have been further developments and discussions, but what I'm going to particularly focus on is Lord Bingham, because he seems to have had such a major contribution, so much so, as you'll see later, is that The Guardian, in one of their articles where they're looking at book review of his book, they say that his work on the rule of law is something which is probably going to stick with our legal system for about 120 years, so you know, it's quite a lot of time that they expect it to stick. So I want to start with Dicey's definition, or actually I think it's mainly like 3 characteristics or features of the rule of law, because he doesn't have like a one definition, he gives like 3 aspects of it. So I'm not going to go into too much detail into Dicey because the point of this video is to look at Bingham. So let's start by looking at A.V.Dicey. Now, the 3 characteristics he says about the rule of law, what are they? Well, the first is, he says, no man could be punished or lawfully interfered with by authorities except for when breaches of law are made. So what he's saying is that any action taken by the state has to be authorized by the rule of law. The state cannot take actions whereby the rule of law has not been authorized. It's like a function of rule of law, you could say. You could say it is the function of the rule of law to give authority to the state to take decisions regarding societal behavior and other issues, other such disputes, family disputes, and so on. Sorry about the lighting. The second thing he says about the rule of law, he says that when we look at the rule of law, no one is above the law, and everyone is equal before the law, regardless of their social, economic, political, racial backgrounds. So the rule of law, it promotes equality because it sees in the eyes of the rule of law, which gives authority to the state, it looks at all people as equal. Now, again, this is also a disputable feature of rule of law, because you could say that MPs are not treated the same as normal people. We'll look at this more in Bingham, but I'm just giving you a glance of Dicey. I don't want to go into the criticisms, etc. The last thing Dicey says as a characteristics of the rule of law, it says that the rule of law it includes judicial decisions, so determining the rights of private persons. So it's not all about written Bill of Rights, or it's also about precedent, what judges say. And also the extent to how much judges have this discretion, and whether this discretion is a good thing, is again a disputable matter, and it would come under as criticisms, which I don't really want to look at. So it's 5 minutes, so we're doing alright, so I'll move on to start talking about Bingham, and there might need to be a part 2 of the video. Okay, so according to the Guardian article, which I've mentioned several times, I'll put a link up for it for all of you to read. Lord Bingham's contribution after Dicey's definition was the next big thing in the legal world, and they say will probably be used for 120 years. I don't particularly like that idea because law is something which for me is evolutionary, and only by critiquing existing ideas can new ideas be born, and these ideas are going to be even better because they will not have the same issues as the previous idea. This is how things develop and how our law can develop and adapt to our legal to our situation, and the sort of parameters which make up our worlds, because they're not the same as they were in 1885. So Bingham summarizes the rule of law by saying two things. Firstly, he says that all people, whether they're private or public, are bound by laws. Now, these laws are publicly made, they have a commencement date, so they start a particular period, and they are administered by the court. So, but all the people, whoever they are, they're bound by it. The rule of law is supreme. And the second thing he says is that the rule of law is a rule of law entitles all people, whether they're private or public people, as discussed before, they entitle these people to benefits of the law. And again, what law are we talking about? What benefits from what type of law they're going to get? They're going to get it from laws which are made publicly, they have a commencement day, and they are used and administered in courts. Then he extends this definition by giving, a fuller picture of what the rule of law actually means by proposing 8 principles which refer to the rule of law, and those are: the first one is, he says the rule of law is clear and accessible for all. I would question this because it's not possible for one to know all the laws that exist. And is it really accessible for those people who have not studied law, or they don't have the reading capacity or understanding capacity to understand the law? Because it's difficult. That's why doing law at university is such a tough thing to get into. The second thing he says is that any questions to do with legal right and liability, they should be resolved by applying the law and not discretion. So what he's saying here is that disputes should usually be settled by looking at legislation and stuff more than it is with discretion. It seems to be a one-off. I don't like this idea. I think there should be a 50-50 chance, because precedent and discretion, I feel, is what gives the law a chance to develop. And as I pointed out before, law is something evolutionary and it needs to be developed in order for it to improve and be the best system it possibly could. The third principle he goes on to say is that the law should apply equally, and this is similar to Dicey. He says the only exception is where there are objective differences. So, for example, if there's an age difference between a child and an adult, or if someone has mental health, things like that. Again, is the law really applied equally? What about those footballers who can afford to have injunctions in order to disadvantage the press from entitling the benefit from the law of the Freedom of Press Act, whatever date or whatever it is? And fourthly, he says that public officers and ministers, they have powers, yeah, but they must use their powers in goodwill, in a good way. They shouldn't use it for their own selfish means, and they shouldn't exceed their lawmaking powers. They should just they should use it in a purely objective way and be satisfied with the lawmaking power that they have. Fifthly, the rule of law must protect and accommodate human rights, which fairly basic, easy to understand. Sixthly, he says that the rule of law is there for resolving genuine disputes without a cost or a delay. Now, even Bingham himself recognizes that this is a more of an ideal, aspirational sort of attribute of the rule of law. You do have to pay here. There are costs if you want a good legal representation, and there are delays. Like, there's always time lag because there's so many cases and so just not enough legal action, as to say. Seventhly, or on the seventh point, is to adjudicate procedures provided by the state. Adjudicative procedures provided by the state should be fair. That's a quote. What that actually means is that the legal system basically should be fair. This is a really vague kind of statement. It's not really saying very much. And again, sometimes it's ideal because, like, how do you know what fair is? We can't put a clear-cut definition on that. And lastly, the eighth point is that the rule of law, for the rule of law to happen, the state has to abide by international law, as it were national law. So, it can't just work on its own. Country has to abide by international law. And this is why Lord Bingham also had a load of problem with the Iraq War, which makes sense in the international world. But again, for some legal cultures and systems, it just doesn't make sense because there's such a clash between, their customary legal traditions as that of Namibia with their human rights. And that's why we had, when the colonization happened in Africa, the British had a principle of repugnancy that if it clashes with their rule, which was at that time the international rule that the British and all the British colonies that they were trying to make them use, then they would say that the law is repugnant. And maybe that's what's happening now, but some parallels. Maybe I'll do a video on that. It's an interesting thought to think about. Anyways, I just thought I'll share this with you. I've got it all done in the video, and it is pretty long, but I had a lot to say. Thank you for watching.